Good afternoon, I'm Jerry Carter with the Sierra Crest Business Law Group. Today I'm talking about the differences between mediation and arbitration and the relative advantages and disadvantages of those two forms of dispute resolution. First thing we should talk about is what is mediation. Mediation is a form of dispute resolution. It is entirely by agreement of the parties, and basically parties that have a dispute will either pay a private mediator, or if they're in court, they'll go in front of a sitting judge and ask that mediator or judge to hold a meeting where everybody talks together or maybe in separate rooms, and the mediator goes back and forth and works out a resolution between the parties through total agreement. There are two types of mediation, like we've talked about. One would be public mediation, and that's where you already have a pending court case, and either the judge in your case or one of the other judges in that courthouse will hold a settlement conference. The other is a private mediation, where the parties agree to split the cost to purchase the services of a private mediator. It might be a practicing attorney, it might be a former judge. And with mediation, the key is that the process is totally non-binding. Either you reach an agreement or you don't. If you don't reach an agreement, there are not any penalties or consequences. And so everybody retains their freedom of choice in the process. Now, arbitration is a different style of dispute resolution. That's a style where you're actually asking some person or organization to decide your dispute. For whatever reason, the parties don't want to go to court to resolve their dispute, and so they privately pay somebody to do that. Examples of private arbitrators would be AAA, the American Arbitration Association, or JAMS, which is another well-known organization. Arbitration can sometimes be part of the court system. For example, here in our city, in Reno, in our county, Washoe County, cases that are filed that have a probable value of less than $50,000 are routed into an arbitration system where you'll be assigned to an attorney, being your arbitrator, and the attorney will render a decision after holding a hearing, and that decision has to be under $50,000. And you can have it reviewed by the judge on a limited basis, and you can also, if you disagree with the decision, you can take that to a jury trial that's not quite standard. You only have 4 jurors, and it's a very short trial proceeding. And so that's just a system, a diversion system that our court system has come up with, but it's totally public. It's part of the public system. Now, what are the advantages of participating in a mediation? There can be quite a few advantages to mediating a dispute. The first advantage is that it's I won't say entirely risk-free, but it's pretty risk-free because your hands aren't tied, and if you either come to an agreement or you don't, but you can't be forced into an agreement that you're not willing to live with. The reason I say that it's not entirely risk-free is that during the process, you will be giving information about the strengths and weaknesses of your case, and it may be an opportunity for the other side to size up those strengths and weaknesses. They may learn something that they didn't already know. Now, is that an enormous factor to consider? Probably not, because if you go to court, then all that stuff's going to come out, and so there's really no overriding, compelling reason to stay out of mediation because you're worried about people learning about your case. Another advantage of mediation is that it's a process that allows you and the person or business you have a dispute with to work things out confidentially. If you go to court and you file a lawsuit, a lot of that information is available to the general public. But if you are, if you engage a private mediator, then your dirty laundry won't be out there for everybody to see. Another advantage of mediation is that when it works, it saves the parties a lot of money. The cost of informally resolving the dispute with a mediator is dwarfed by the cost of going through the whole jury trial process. And last but not least, there's something about the mediation that it actually works. And it's funny because when you have a settlement judge or a mediator going back and forth, sometimes you know that they're coming into your room and telling you how bad your case is and how the other side would trounce you if it went to court. And you know that person is going to the other side and then saying the same thing, that their case is bad and that you're going to trounce them. And you kind of understand that, and yet despite all of that, it really works. And I think that the reason is that a good mediator is someone with a pretty diverse background and a good sense of how to value a case, and the parties usually are able to sense that, and so that mediator's got some authoritative clout just by virtue of his or her experience. Another reason is that a good mediator is good at sizing up a case and asking the right questions to bring out the salient parts of the case and focus everybody. And so they can really create collaboration where none existed before. Also, that mediator gives you a valuable outside perspective. When you're in the middle of a business dispute, all you see is how wrong the other side is. All the other side sees is how wrong you are, and it's helpful to have the perspective of someone who doesn't really care one way or the other how the dispute unfolds, but can give you an outsider's perspective. And once you're able to see how the case looks to other people, magic things start happening. And then lastly, a reason why these mediations work is because it focuses everybody. Instead of dragging things out through a long process, everybody prepares and comes into the same room, or at least the same building, on the same day at the same time, with an attitude that they want to resolve the case. And just having that amount of focus, simultaneous focus, all at the same time, is something that enables parties to come together. And so, surprisingly, or not surprisingly, a lot of cases that go into either private or public mediation are resolved at that stage. We're still talking about the relative advantages and disadvantages of mediation and arbitration. And so we've already reviewed that arbitration is a form of dispute resolution where you engage a private arbitrator who will listen to each side's version of the dispute, review the pertinent documents and other evidence, and even take swear-in witnesses and hear their testimony. And that arbitrator will make a decision. And one side will like the decision, the other side will not like the decision. Sometimes both sides will hate the decision, and that may be a good sign if they hate it equally as much. Now, what are the advantages of participating in an arbitration? Well, in terms of arbitration versus going to court, arbitration is going to give you more confidentiality. If you're in court, then your dirty laundry is there for everybody to see, whereas in arbitration, you are, a lot of that is confidential. Second, sometimes when you're in a specialized industry, you can get an arbitrator who has experience in your industry. If you go to court, you're going to get a judge and you'll get some juries, but you won't be able to tell ahead of time whether that judge or jury has specialized knowledge and experience in your industry. Whereas with arbitration, you have a much better chance of being able to get that judge who knows your industry. And then a third advantage of arbitration, and I say this with a little bit of an asterisk, is that it can be quicker than going to court. And the reason I say it can be quicker is that you really have to build that into the ground rules of the arbitration before you go to arbitration. Otherwise, it could take as long or longer than a court proceeding. But I have had situations where the parties said, look, we're going to get this resolved one way or the other in 3 months, and we're just going to agree to go to an arbitrator and tell the arbitrator that we want to hear this on an expedited basis and we want the decision by X date, and we're going to kill ourselves to get to that point. And so they got the speed, but the key is you have to build that into the ground rules ahead of time. Now, are there disadvantages of going to arbitration? The answer is yes. One disadvantage that some people don't always appreciate is that it's extremely expensive. If you go to court, then you need to pay your attorney and you're going to have some of your own costs in the deal. But if you go to arbitration, not only do you pay your own attorney, but each side pays half of the arbitrator fees. And the arbitrator fees can be substantial, especially if the arbitrator is actively involved in preparing the case for the hearing and overseeing the hearing. You pay for all that time, the time that the arbitrator spends reading evidence, listening to evidence, preparing his or her arbitration award. All of that gets paid for by the parties, and the bills can be pretty high, especially if you have more than one arbitrator. Sometimes you go to arbitration, you have 3 arbitrators as a panel. All those arbitrators get paid, so there's an expense. Second, which we've already talked about, is you can be disappointed with how long the proceeding takes. Unless you've built in special rules, it can take as long or maybe even longer than a court proceeding. The third disadvantage or possible disadvantage of arbitration is there may be situations where there can be some structural bias. And by that I mean that if there's an arbitration panel, and this happens I think with consumer arbitration, sometimes banks or contractors put in their form agreements that you have to arbitrate with such and such a panel if you have a dispute. Well, generally that panel is a panel that exists because of the big players in that industry pay to create that panel. Or in the case of other panels, maybe they don't exist because of your adversaries, but your adversaries pay in the arbitration fees, and they you always know that they know what side of the slice of bread they get their butter on. And so there's a possibility of a structural bias where maybe a consumer is going up against a bank in a forum where the arbitration organization gets paid by the bank. And so that's something that's always in the back of your mind, and you got to look for possibilities of a structural bias. Now, the last question is, what would you do if you had a choice between mediating and arbitrating? Mediating, going for a mutual agreement; arbitrating, just going for that decision out of court. The good news is you don't always have to make that kind of a stark choice. You can test mediation and try mediation, and if you're unsuccessful with that, then you can either go back to court or go to arbitration. And so really, in that instance, it's not a question of which one you do, but maybe in which order you go. And so there are a lot of considerations to think about when you're deciding on how to resolve your dispute. And what I would encourage you to do, if you have a business dispute, is to sit down with an experienced business attorney to go through the various permutations of your specific situation and what aspects of your situation weigh in favor of arbitration versus mediation or going to court, or working things out, outside of court. If you take the time to go through that analysis, you'll be in a much better position.